of the citizens, of our children. And I just, for the life of me, when you look at the fact that emissions aren't going down, you're looking at the fact that spending is out of control, I think there is a better way. And in the next election, Canadians will have that opportunity to ask themselves, what is that better way? And I think they will find that common sense will prevail. Thank you, Chair.
Okay, thank you. Next, I have Mr. Batiste.
Thank you, Mr. Chair. I'd like to get back to talking about First Nations children in this community and in this committee in the future. I'd like to make a motion to adjourn debate so that we can continue on the important work that we have today.
So we'll call that question. So all in favor, do you want it recorded? No, that's a dilatory motion. There's no debate after it. So we have a motion to adjourn debate. So all in favor? We'd like that recorded.
Mr.
Okay.
Batiste?
Yes.
Mr. Carr? Ms. Gainey? Mr. McLeod? Mr. Pawlowski? I guess it's 4. Mr. Emilio?
Against.
Mr. Schmale?
Against.
Mr. Shields?
No.
Mr. Zimmer?
No.
Monsieur Lemire?
En faveur.
Ms. Gazan?
Support. In favor. Point of order, though, Chair.
Okay, your point of order.
I'm a visitor in this committee, and I know this is politics here. But if they're going to talk about First Nations, I'm going to talk as a First Nations mother, and I can tell you the biggest issue in our community is child welfare and the fact that our kids are dying in the system, and the fact that the Conservatives in this committee today are talking about life and death and how hard it is for families. I'd like them to come to Manitoba, where 90% of the kids currently in care are First Nations, who are dying in the system, going murdered and missing as Indigenous women, and then we'll talk about urgency. I find it disgusting.
I'm going to stop there. That's not a point of order, but we've just
so that the public knows what games are being played on the backs of the lives of our kids in this committee.
Yeah, we have voted in favor of suspending debate, and so we will now return to the questions. And so next up I have on my list Mr. McLeod, who will have 5 minutes.
Thank you, Mr. Chair, and thank you to our witnesses. Thank you for joining us today and providing us some very important information. I understand that the government of the Northwest Territories chose to intervene in this case before the Supreme Court in support of the government of Quebec's challenge to C-92, and their involvement in this case was strongly opposed by the Inuvialuit Regional Corporation, who have already passed their own child and family services law. Are you able to speak to the arguments brought forward by the government of Northwest Territories and how the Supreme Court's ruling addresses their arguments?
I turn to my justice comments.
Thank you for your question. Unfortunately, I'm not today, but if you'd like, we can follow up with a written response to that question.
Mr. Chair, I was hoping that we would have some very forensic information detail when you come to present to committee. This is my writing. This is their involvement. It kind of leaves me out in left field when witnesses come unprepared. I'll have to wait to get the information in writing, I guess. But I'll ask us another question. If the witnesses could provide an update on how Indigenous governments in the Northwest Territories are moving forward with their own self-determination following C-92's implementation.
I can answer that question, and thank you for it.
I think you made reference to the Inuvialuit Regional Corporation, who are in the process of negotiating a coordination agreement. That process continues. I can't speak to the confidential nature of those negotiations, certainly, but I do think that what you see for Northwest Territories is what you see elsewhere, is there's an affirmation that the work that's been happening under C-92 can continue as the Act has been found to be constitutional.
My third question is regarding the challenges that may have been observed to date with off-reserve communities. As you probably know, the Northwest Territories has a majority number of Indigenous communities, but they're public communities, not on reserve. So how are these challenges facing some of the modern treaty governments in Northwest Territories and their ability to move forward with their own child and family services legislation?
Thank you for the question. I mean, absolutely, and not, the diversity of communities across the country is recognized throughout the statute, and it is a distinctions-based approach that we adopt in co-development with partners. We are in conversations with communities who are using modern treaties. We also have colleagues on the CERNA side of government that work directly with modern treaty holders, and there's an optionality that's available to those communities, whether they wish to use the Act or they wish to use the modern treaty process. To access child and family services jurisdiction.
I see in section 22, brackets 3 of C-92 that Indigenous laws prevail over provincial or territorial laws in case of conflict. Could you tell us why that was important to include it in the bill?
I'll defer to my Department of Justice colleagues. Thank you.
I can certainly comment on how that section works. I don't know that I have the background in terms of the intentionality behind inclusion of the provision, but if it's useful, I can talk about what that provision and what Section 21 does. Really what 22.3 is putting in place the legal doctrine of federal paramountcy. So basically, that provides that provisions of a federal law will prevail over a provincial law. So the combination of Section 21 and 22.3 mean that Indigenous laws become incorporated as federal laws under the Act, and then through that incorporation by reference process, those Indigenous laws then are paramount over provincial laws if there is a conflict or a situation of an inconsistency. So significant provision in terms of ensuring that those laws are paramount over the provincial laws that could be inconsistent.
Okay, thank you. We're out of time, and we'll now go to Monsieur Lemire for 2.5 minutes.
Merci, Monsieur. Thank you, Chair. Indigenous children are removed from their families, citing different reasons, including improper housing conditions, and parents and Indigenous communities sometimes do not have control over these factors due to lack of financing, which of course is something that could be solved by the federal government. So in the context that's before us, where we're looking at $1 billion that's been distributed, I'd like to know how much of that money has been distributed in Quebec to date, and how these negotiations have taken place, and what communities have benefited from this funding. You're asking this in connection with the coordination agreements? Well, we are negotiating currently with Obijuan community, but the amounts are not known yet, and the amounts will be will be clear by the end of the year, at the end of the negotiation process. It's been 4 years since the Act received royal assent, and there's been court challenges. So if I understand correctly, things have been put on pause in the meantime, rather than moving forward and distributing this money. So as a result, it's still, once again, the children that are paying the price. So the Department of Justice maybe can answer this question. What precedent does the ruling of the court sets, because the Quebec was asking for a respect for its jurisdiction, but what kind of precedent does this create in terms of the relations with the provinces?
So, merci pour votre.
Thank you for your question. I'm going to answer in English.
Court found that the law was within federal legislative jurisdiction. So in terms of extrapolating going forward, it's an opinion of the court, it's not a decision, so technically it's not binding, but it is treated as a precedent. Ultimately, they did find it is within federal Parliament's legislative jurisdiction. So it's very difficult to speculate in terms of going forward what this means. I think they were very careful to speak directly to the legislation that was in front of them and the question that was in front of them.
Je pense qu'on peut quand même spéculer que si vous avez la compétence.
You could still speculate that if you have the jurisdiction, you're going to pay for it.
Ms. Gazan, you have 2.5 minutes.
Yes, thank you so much. So we're talking about children and reconciliation. I know I asked you a number of questions about Bill C-92 and monies attached. Recently, actually, the Conservatives put forward a bill, Bill C-318. I offered up amendments that were supported by the sponsor of the bill to include in the new EI funding regime for adoption, to include kinship and customary care to ensure that this government was upholding the rule of law, which now includes Article 5 of Bill C-15, which states that the Government of Canada, in quotes, must, in consultation and cooperation with Indigenous peoples, take all measures necessary to ensure that the laws of Canada are consistent with the Declaration. It passed in committee, making the bill now consistent with Article 19, 20, 21 of the UN Declaration on the Rights of Indigenous Peoples. It was thrown out by the Liberal government, even though they have the ability to provide rural consent. I wrote a letter, in fact, to the government on February 27th, 2024. The government still has an opportunity to uphold the rule of law. I'm wondering if we're talking about reunifying kids. We know that 90% of kids in care, certainly in Manitoba, are First Nations, often in kinship and customary arrangements. Does this government have any plan to uphold the rule of law and amend that legislation?
For me, I would be unable to answer that question. I can certainly endeavor to provide you with a written answer. It's outside my purview.
Yes, I do think we require a written answer, but I also think it's very timely because if you're not willing to change legislation when you're talking about child welfare systems that will essentially exclude 90% of the kids in care, it's probably not a very effective piece of legislation. I know that the government currently has a Bill C, I believe it's C-59 in place around adoptive care. I'm wondering if the government has any plans to ensure that they uphold the rule of law and make sure that it's consistent with Bill C-15 and Articles 19, 20, and 21 in terms of adoption care. Is there any plans
we're out of
for
time,
that?
but if you can answer
Thank
briefly
you.
in a sentence or two, that would be appreciated.
To speak to that question, but I can certainly bring it back. Yes.
That would be great. Thanks.
Thank you.
And our clerk will be keeping track of all of the written questions, so we'll be following up with those. We will now move to Mr. Malillo, who will have 5 minutes.
Thank you, Mr. Chair. Thank you to the witnesses for being here on this important discussion. Just want